Welcome back to another episode of the Human Side of Wealth. I'm very excited for today's show. We have Rawson Hubble, the Director of Estate and Trust Services here, and Steve Reeder back with us again, the President of Private Wealth. Guys, welcome.
Thank you.
Thanks for having us.
Glad to be here.
Today we are talking about a subject that sometimes many people put off, but we're going to tackle it today because it's one of the most important parts of your financial plan. So we're talking about estate planning, okay? So big topic. Rawson, I'm glad you're here to help us demystify some of it.
We'll see.
It can be as complicated or as simple, I think, as some folks want it to be. But let's start with the basics. Let's start with the why. Why is estate planning so important?
Andrew, I think it's primarily it's coordination, right? To make sure that you've covered as many bases as you can, not if, but when someone dies. To make sure that we've made things for your family smooth, been smart about saving money where it makes sense, but I think it's really the smoothness and making things work with the least amount of hassle.
Yeah, we talk about deciding who's in charge, right, as a basic point.
Yeah, just a lot of the blocking and tackling just to get in place. Who's going to be in charge and take care of it if you're incapacitated, or if you do pass, who's getting what? How's it getting transferred to them? Trying to cut down on cost and complexity and avoid that can happen in the passing, and just trying to simplify things for your family or whoever your assets are going to.
Right. And Rawson, I know one concept that I've heard you talk about quite a bit is this idea of flexibility. That's a key word when it comes to estate planning. And why do you feel that way?
Yeah, it's interesting because I think it's a yin and a yang, right? So there's flexibility and control.
Yeah.
Right. So the more control you put into your plan, sometimes that's at a cost of flexibility. So mostly what I'm thinking about when I mention flexibility to clients or prospects or someone is the idea that you're making decisions when you have to. You don't need to put in place a plan today that's going to be locked in place down the road. You want to keep often it's a surviving spouse. You want to maintain flexibility for the surviving spouse. Sometimes it's flexibility for the kids. A lot of times it's flexibility for myself. I want to change my mind in 3 years. Sure. So just flexibility is really important. Sometimes that comes at a cost of control. So if I am really sure that I want my spouse to not be able to mess up money, which can happen, or if my spouse wants me to not be able to mess up money, which is more likely, then they can put in more control. But a lot of times we're trying to give that flexibility primarily for the surviving spouse.
Right. Yeah, I've heard it. One phrase, build in some off ramps, right? Potentially in the documents that you create. So in terms of documents, let's cover some of the basics, right? What are the foundational, maybe we'll say, documents that you think are, significant, important must-haves?
Yeah, I think when people first start off with their estate planning, they typically it starts with they get married, and then if they have kids, and so it's creating some power of attorneys, healthcare power of attorney, getting a will in place, maybe getting a trust in place, making sure you have guardianship in place for your children, and those are some of the foundational things that I see people start with.
Yeah, and healthcare documents, right?
Yeah,
we want to make sure that we've got appropriate healthcare documents for someone laying out their own wishes and giving somebody power to execute those wishes.
Yeah. Why is estate planning such a difficult conversation?
Facing death. I think it's the fear of facing death at the end of the day, and people do hesitate to talk about it. And it's interesting because as we get plans in place for someone, they're also, it feels like they get hesitant to revisit them. And so one of the things that I see when we work with our clients is those documents, unless we intentionally are bringing it up, can start to get dated. And it can, 5 years can become 10 years, can become 15 years if we're not helping them kind of bring that to the forefront.
And I also think there's a little bit of reluctance to go forward with it because you have to kind of commit to stuff sometimes. Now, you remember I said about flexibility. I want to make sure that our clients can change their mind. But you do have to kind of commit to a program at some point when you do this. So a common thing is if you have 2 children and one of them really has their act together and one maybe less so, shall we be to be generous, then people don't want to kind of admit that. They're reluctant to kind of address that, and you just got to address it.
But I think another thing is the conversations aren't necessarily happening at home. Like if you go out to dinner with your wife,
Yeah,
how many times is this coming up? Like it's not
Maybe
like
for you quite a bit.
that's right.
Yeah.
It's not really a hot topic
Yeah.
though.
Yeah.
And
no.
it's hard to find the space that it feels comfortable to bring it up.
Yeah. I've been in many meetings where it's the first time. I'm sure you both have too, the first time that this subject is being brought up. But it's enlightening, I think, a lot of times for clients. And so, Steve, you mentioned one thing too, and we've seen this, right? We're building a financial plan, find out, okay, your kids were born back in 2003. Chances are that's probably the last time the estate plan was updated.
It's called an I love you will.
Yeah.
And you see this all the time, right?
Yeah.
And somebody's got young kids, they want to make sure they put in place a structure where if they die, everything goes to the spouse, and then the spouse makes whatever decisions are going to happen.
Yep.
And there's, everybody had one or has one, if they may not have updated it, but everybody had something like that.
Yeah. So in terms of that, Rawson, I mean, you work with all of our advisors here. You've, been in hundreds of client meetings now at this point. What do you see as common misses or common themes maybe that pop up in a lot of the conversations that you're part of?
I think the most common things that I see are a couple of fold. One is cost, where it's not necessarily the most efficient plan. So, for instance, people that have a plan where they use a will to distribute their assets, it requires probate. And we'll talk about probate in a second, but let's say, but it requires probate. And so there's extra cost that goes along with that probate. Similarly, if you have one of those I love you wills type things, a very simple plan, in Massachusetts anyway, there might be an extra cost from estate taxes. A lot of states don't have them. Massachusetts does have an estate tax. The federal levels right now are so high that it's just not that common to have there are $30 million for federal taxes, $15 million per person. Married couple, it's really $30 million for a married couple instead of the $15 million a person. But in state taxes, it is really per person. So you have to it's not hard, but you have to do a little bit of planning to make sure you can use both of those exemptions for a married couple. So that's a bad thing from a cost standpoint. I think we were talking about who you're going to put in control. A lot of times that's a very dated notion that you've got in your documents where you thought that your brother-in-law was going to be the person to be in control, and now that's not such a great idea. So that's something I think needs to be updated more regularly. I think that's pretty important to stay on top of that. So problems. Will-based plan instead of a trust-based plan. Again, we'll get back to probate in a minute. And then I think the other biggest thing I see, in addition to the tax problem for states that have an estate tax, is outright distributions to kids at certain ages. And I want to talk about that a little bit later too. But I want to make sure that we address that, because the idea of giving your kids money, let's just say a third at 35, half at 40, balance at 45, that's a very common scenario. In a lot of cases, that might be great. But it opens up a really good discussion for the benefit of maybe keeping it in trust for the child's life. And we can talk about that in a little bit. But.
Should we talk about probate? Is it time?
Yeah, this is so exciting.
Should we?
I've been waiting.
I know you. Lead us on. So probate, right? Lot we can talk about here, but where would you start? I guess maybe can we start with you, Steve, on probate and where you see that sometimes being an issue?
It just adds a whole layer of complexity that I would, I guess, prefer to avoid. And I think most people can't avoid it with intention. And so it's just, as I kind of talked about earlier, like just getting clear on, how are we transitioning assets, through what vehicles, how are they getting it? And if you have things in place, even beneficiaries updated, if your accounts or joint accounts with you and your spouse, a lot of things automatically transfer that allow us to avoid it altogether. So where I would start is my personal preference would be, how do we avoid probate? Let's just make sure we have everything in place to do that.
Proper titling, right? That's a good place to start as any.
How to avoid, but why are we avoiding probate, right?
Why?
What's bad about it? So probate is it's a process. We're using the probate court in whatever county or state you're in, it's really a system that's designed for creditors of the deceased. Okay, so they have an ample chance to come in and wave their hands and say, Andrew owes me money, right? Not that you owe anybody money, but that Andrew owes me money. And so when you have that process set up, you're on the court's timeline. There's extra cost involved with that probate process, and it's a public process. So, you see fabulously wealthy people that don't have, we'll talk about again, revocable trust, who go through, whose estates go through probate, and then the world sees that, that Joe Smith died with $35 million and he has 2 kids, and one of them is special needs. So now we've got a special needs kid that's going to inherit $17.5 million. That's not usually a really good recipe for a successful outcome. So doing what we can to avoid probate, so that's going to be titling, and it might be creating a revocable trust, and I'll talk about that in a second, but titling is important. Most stuff can avoid probate through proper titling and beneficiary designations. Most states, you can't do that with real estate. So if you own real estate, that's almost always going to go through probate. So what we're doing with revocable trusts instead of wills is we're titling assets, non-retirement assets, into that revocable trust today. So you put the house into the revocable trust. You put your investment accounts, again, not the retirement accounts, but the other non-retirement investment accounts, into that revocable trust today. If you have an LLC or a business, you transfer those interests into the revocable trust. So to the extent you've got assets funded into that trust, there is no probate because it's already owned by the trust. When you die, it's still owned by the trust. You're not changing titling on any of that. So that's just it's a much more common way, especially as you get either more wealth or as you get closer to needing probate, meaning older. So that's that kind of is that's the idea on trying to avoid probate.
So let's dig into just trusts for a second. This is a whole rabbit hole we could go down, but I think just the word trust often sometimes evokes maybe ideas of, oh, it's too complicated for me, or I don't need it. Those types of conversations. How do you navigate those with clients?
So a trust is really just a couple of relationships. That's really what it is. You've got a trustor or grantor. I'm creating the trust. You have a trustee. That person's job is to take care of, follow the rules of the trust and make sure the trust is doing what it says it's supposed to do. And you have beneficiaries. So that's the person for whose benefit that trust is designed. In the trust we've been talking about right here, the revocable trust, they're all the same person, right? So really the only purpose of that is to avoid probate. In some trusts, they are different people. You might have other people involved in that, and have irrevocable trust. There are a lot of other kinds of trusts, which we're not going to kind of mess around with today. But in the basic trust design we're talking about today, the revocable trust, it's all the same person. And it uses the client's social security number. It can be changed as much as they want. So once clients understand it, it is completely, is unintimidating a word? I don't know. It's not at all intimidating once the clients understand it.
No, I like that.
But I think it has a very good purpose at even like a basic level, which is, it is, in my opinion, it's like the best way to make sure that your wishes are followed. It's a lot more concrete than just writing a will. It has a lot more teeth or validity than a lot of those. You can't just tell the world what you want to do and the courts and everyone else are going to go with it. The trust really solidifies, like, these are our wishes, this is what we want to have happen, and it is one of the best ways to make sure that that happens.
When we think about proper titling, beneficiaries, a trust-based plan, as we kind of led off talking about, estate planning, it's already an emotional topic, understandably, right? When a loved one passes away, the last thing you want to deal with is things all over the place. Who gets what?
And it triggers multiple steps potentially, meaning, if you have an account that's set up a certain way, let's say you have your spouse as the only sole primary beneficiary, well, what happens if you both pass in the same incident? Then it's kind of hanging there. Whereas I feel like a trust is much more, most people are more intentional that if A happens, then B happens, and then if C happens, then D happens. And it just is a little bit easier way for people to control the destiny of what is essentially going to happen with their assets.
One anecdote, if I could just add on to that, is that when we talked at the beginning about estate planning or whatever it is, everybody has an estate plan. It may not be intentional, and it may not be by design, but there is a plan in every state. If you didn't draw up any documents, it's going to happen. And it's just it's by the laws of the state, in our case, of the state of Massachusetts, that's going to say what happens. Nobody likes that. People like to choose their own estate plan. So everybody's got one. It's just whether it's something of their own choosing.
Well, there's at least one story in the news every year about a celebrity that
Yeah.
passed away without a will or wrote something on a napkin and and all that. So Ross, I want to go back to, you mentioned, want to go deeper into this concept of setting up an estate plan for kids, a trust in that sense. Maybe talk a little bit more about that.
Sure. So I think that would kind of go back to what I was saying about it's very common to say we're going to have age-based distributions, and my kids are going to get such and such at one age, and then some more at another age, and then maybe the balance at a third age. That is very common, and that works very well. I mean, it's a very certain. We're talking about certainty and flexibility, and there's a lot of certainty in that outcome. But sometimes it's not always the best, because sometimes our clients recognize that their kids might have potential exposure to kind of a lawsuit or a divorce or who knows what it is. And by giving your child their share, and if it's $500,000, it may not matter quite as much. But if it's $3 or $4 million, it might matter a lot more. Giving your child outright ownership of those assets at any age exposes those assets to a couple of things. One is a lawsuit, right? It exposes it to creditors. Creditor might be a divorcing spouse, could be a car accident or a slip and fall. So it's exposed to that if you give it to the child outright. By leaving it in trust for that child's lifetime, you can substantially reduce that potential exposure. That's one thing. And the next is taxes. By keeping it in trust for the child's lifetime, you're saving a generation of taxes. When they die, it's not part of their taxable estate. So if they live in a place like Massachusetts with an estate tax, you're not compounding the problem. By leaving it outright to them, you're going to add it to their estate tax in Massachusetts. If you leave it in trust, it avoids that. So there's a lot of reasons why clients don't do that, because it is, I said, it's easier just to say, look, I'm dead, I'm going to give my kids their money and they're going to be okay. But there's also a lot of cases where people say with more money or with maybe a potentially less certain kind of relationship with the spouses, that they want to make sure that money stays in the family. And that's what you do with lifetime trust. You ensure that it stays in the family. You can get more control, less control. There are a lot of different ways you can design that, but that's the reason people do it.
We talked in our tax episode about this idea of permanency, right? With a lowercase p.
Yeah, right, exactly.
Also applies to the estate planning rules around federal estate tax. So maybe let's spend a minute or two talking about that high level. Obviously, like you mentioned, 15 million per person at the federal level. Sounds like a lot, maybe not forever though, right? So how are you thinking about planning now? Because one word that comes to mind for me is maybe complacency, right? Oh, great, it's 30 million. I don't need to worry about the federal estate tax. That's gone for me. Why not?
Well, there are a couple other reasons why you might be more proactive about planning for that now. One is if you plan for it now, you're going to get growth outside the estate. Another is that same asset protection concept. There are a couple other unique features of trust that make them work well from a tax standpoint. But I think the key thing is they're small p on the permanency, right? It can change. I'm not pushing really, I guess if we had a $150 million client, I would be saying we need to take some steps now. But for most of our clients, I am a little complacent about that. I guess I want to say that not with a negative bend on it, but to say that if things look like they might change, then we might have to kick into action again. So remember, we were really busy with this last year.
Yes, before the potential sunset.
Before the potential sunset. So we were very busy talking about this last year. Sunset didn't happen. In fact, the exemptions went up, and they were made permanent. So again, that permanent is with a small p, because they can change anytime. Oddly enough, people don't, I think, track this. Income taxes have gone up and down over the years. Estate taxes, I don't think they've ever gone down. I'm sorry, they've never gone up. Excuse me. So the exemption has continued to rise over the last, as long as I've been doing this for 30 years. So the exemption goes up, your taxes go down. So the estate taxes have gone down. And who knows how long they can afford to do that.
Well, all right, so it's 2026. I just updated my estate plan. It's shiny, it's great, I'm feeling good about it. How often do I need to update it?
I mean, it's kind of a trick question
Yeah.
because it depends.
Yeah.
So it depends what happens in your life. So I think if major life events happen, for sure you need to take a look at it. So children are born, marriage, divorce, something like that. Anytime a life event happens, you should trigger in your mind that let's make sure this gets aligned. I think absent of a major life event, I mean, still every 3 years, we should be dusting it off and taking a look at it and making sure there's nothing that drastically changed. Rawson mentioned it earlier. I mean, a lot of things that are likely to change are the players, so the people that are involved. You know, the people you put in as trustees or co-trustees, or you know, people that you want as part of your trust or your estate plan may not be part of your life anymore for a variety of different reasons. So those players may change. You want to make sure that there's people that are in your life that you want to execute those, but those are some of the things that pop out to me.
In-laws can change.
Yep.
Yeah. So we just touched on that, but
Yeah.
I think sometimes I've seen a little bit of this recently. Is that as not just when kids are born, as your parents get older, then it kind of triggers a little something too. So we see a lot of people. Hypothetically around age 60 that are also looking at their planning because they've got aging parents.
That's a great one. That's one that I'll put in life event, but I mean,
Yeah.
diagnoses happen,
Sure.
health issues happen, and when something like that pops up, absolutely, people pay more attention to it, and they should. It's definitely another big life event that we see people really pay attention to the estate plan.
Right. Another one potentially too, if you move states.
Of course.
Right?
You bet.
Just to throw that in there too. As you mentioned, we're talking about Massachusetts, right? But we have clients in all 50 states, and it can get, you know, obviously it's different from state to state, so that could be another trigger.
Yeah, I mean, understanding, community property versus non-community property, understanding whether a state has a state tax or not a state level estate tax, or an inheritance tax and versus not an inheritance. There's just a lot of different complexities moving from state to state.
Yeah.
And even something as simple as a durable power of attorney.
Yeah.
It changes from state to state. So you want to make sure that if you want to make sure your documents are going to work for where you live today.
Yeah. We covered a lot of ground. What did I miss? Any questions you were hoping I would ask that I didn't?
No, I just think that we are lucky that we have clients that care about this stuff. I mean, we do, and for the most part we do. And if they don't, we try to get them to care. But we're lucky that we have clients that care about this. And it's a little self-serving of me to say it, but a couple of basis points here and there on investments can move the needle. But if you mess up an estate plan, or if you pay, $5 million of Massachusetts estate tax when you don't need to, there's no basis points that can make up for that kind of a difference. So this stuff matters. And it can really be, it can matter in a big way for our clients and their families.
Well, it's part of the 4 pillars too, right? I mean,
It is, absolutely. I mean, it fits right in there. When people think about their financial journey and what they want to accomplish, I just think it's so important. We integrate a financial plan into this. We get investment management to make sure we're growing their assets appropriate to their plan. Tax planning in order to maximize their wealth, and estate planning to make sure that, whatever they worked for, that the legacy is left behind that they want it to be left behind. And with intention, you can make that happen.
well, Ross and Steve, we will leave it there for another episode of The Human Side of Wealth. Thank you very much for listening or watching, and we will catch you on the next episode. Thanks again.